Does America's criminal justice system still practice the standard of innocent until proven guilty? Much of the time, the answer is no. So what happened to cause this? 2 words: pretrial services. It all began in the early 1960s with a study called the Manhattan Bail Project, which found that many defendants remained in jail because they couldn't afford the bail, and local people with strong ties were unlikely to skip bond. That idea was the impetus of pretrial services. Lyndon Johnson signed the Bail Reform Act of 1966, stating in his remarks, "A man, regardless of his financial status, shall not needlessly be detained when detention serves neither the ends of justice nor the public interest." Washington, D.C. soon led the way with the first pretrial services agency, and pretrial agencies were then implemented in jurisdictions throughout the country. But the mission changed from the original goal of giving the poor the same pretrial benefits as the wealthy to providing wide-ranging defendant information to the court and supervising the defendants. To give muscle to this agency, additional charges and warrants can be issued for failing to comply. In other words, rather than helping the indigent defendant, pretrial services places defendants on probation prior to being found guilty. To illustrate this, suppose someone is arrested with a misdemeanor offense and is assigned to pretrial services. First, the defendant does not have to pay anything to get out of jail. The defendant is now under the supervision of pretrial services. This means the defendant will have to report to the pretrial services agent periodically. As a bondsman, I see how this can hurt people, especially the poor. I've had clients tell me that they lost their job because of having to check in. Or if the defendant has no transportation, the appointment is missed and a warrant is issued. Depending on the charge, the defendant may have to submit to drug or alcohol testing. If the defendant fails the test, that is another charge and another warrant is issued. There is a common belief that pretrial services sets up people to fail, and this specific practice gives credence to that belief. Also, the defendant may have to attend educational courses, which is to be paid for by the defendant. Seeing this play out, suppose a defendant cooperated and did not incur any additional charges and found not guilty. What about all the time, expense, and burden of jumping through the pretrial services hoops? These penalties and requirements are imposed with no findings or admission of guilt. Now suppose the defendant accrued at least one additional charge from pretrial services. These additional charges brought by pretrial services are now part of the defendant's record and have to be reconciled as any other charge. They are purely a fabrication of pretrial services, and it's especially infuriating when the original charge was bogus and gets a dismissed or not guilty verdict. Pretrial services slaps criminal records on people who are often not criminals at all. All across America, people struggle to get by, to live in decent housing and have enough to eat. They don't need another government agency throwing up more senseless hurdles to maneuver. Further, those advancing the pro-pretrial agenda, whether knowingly or not, appear to be concerned for the poor, but in fact they're exploiting them and are often the primary cause of their burdens. Pretrial Services is a government agency which has perverted our criminal justice system into an entrapment mechanism, which, by trampling on the idea of innocent until proven guilty, sets up many defendants to fail. And as with all bad laws and policies, the negative effects of it are most often harshly felt by the poor, working poor, and minorities. This system is unjust and immoral. It should be stopped now.